Democratic Committee, and I'm also a 2L here at Pitt Law, and I want to welcome everybody to our Judicial Candidates Forum. I wanted to recognize a couple folks who are out in the audience. James Craig somewhere, here he is, my colleague on the Pitt Law Democrats, and also Austin Ross, our kill switch man, who's going to dial it down if we get any feedback. So very important roles here. And I also wanted to give a shout out to Gene Clark, 7th Ward Chair, City Council candidate, and also Dan Gilman, also City Council candidate, and we'll say hello to everybody else after. And Nancy Patton Mills, our chair of the Democratic Committee. So welcome everybody, and hope we have a good time. And I'm going to turn it over to Gene Clark, who is going to tell you what's going down here.
Thanks very much, Ian. This is going to be a different kind of forum than you guys are used to, but we thought you could have some fun with this. It would actually create better informed voters, and we could have a little bit of fun with it. So, as we said in our press release, no stump speeches, just straight answers. Great. We're going to ask you, we'll start on this end with the first question, and then we will rotate who gets the first question. Everybody will answer the same question. We ask you to keep your answers to 1 minute. At 1 minute, Prosecutor Rick Booth will stand up and prepare to arrest you. You can finish your thought.
In jail. In jail, yeah.
And in jail, exactly. But we also thought that we could have some fun with this. I also wanted to announce that sometime during the event we'll be joined by Common Pleas Judge Jack McVeigh, who is running for Superior Court. And I'm sure other candidates and everyone who's running has been invited, and I know some of them are running between your events, family parties, all sorts of stuff. So we're going to try to accommodate everybody. This is also being professionally videoed and will be put up on the Shadyside Dems website, shadysidedems.org, and YouTube as quickly as we can after the event. And we'll be announcing that to the public, that they'll be able to see you in action. So we hope that it will be of value to you. We recognize how hard you're working. We recognize that running for judge is a very serious and hard thing to do. You have to be very political during the endorsement process in terms of reaching out to all of the committee. But then when you get on the court, you have to forget all your friends. The courts would not run without this kind of system, and it's an important part of having the voters may have their say and have judges that they can respect on the court. So our questions have been devised by a committee of active lawyers from the Shadyside Democratic Party, the Oakland 4th Ward Party, and by the law students, and so they're very different from the questions you might have heard elsewhere. We don't really care about your family. We care about the law and about your records. Our moderator today is Lynn Hayes Freeland, who is a general assignment reporter known for live, late-breaking reporting on KDKA TV News. She's the producer and host of the Lynn Hayes Freeland Show, which is a weekly half-hour show that concentrates on local African-American issues. Lynn has been active in Pittsburgh for a very long time. She's an active member of Alpha Kappa Alpha sorority and has served on a number of boards. She's the perfect moderator for many reasons. One is, she used to be my neighbor in the 7th Ward. So she's familiar with how the 7th Ward thinks. And she lives on just the outskirts of the 4th Ward right now in Andover Terrace. And she's a graduate of St. Paul's Cathedral High, which is now part of Oakland Catholic, went to Duquesne University. And she knows how the courts and the law really work, thanks to her father-in-law, renowned lawyer, civil rights activist, raconteur, and World War II Tuskegee Airman Wendell G. Freeland, who is still actively kicking butts and taking names for justice every day. So I'd like to take away, remember, 1 minute on the questions. Lynn, please lead us.
Thanks for that introduction. I'm glad that I don't have to be the timekeeper. I'm glad that someone else will be the one to tell you when your minute is up. We will begin at this end, we'll work down, and then we'll work our way back up. So no one, and we'll rotate who gets to be first each time. And so the first question is going to be, and each one will answer, each of you will answer each question. So the first question is, how long have you practiced law, and in which divisions of the court? And the part two of that question is, which one case are you the most proud of and why?
Hi, everyone. I'm Eleanor Bush. I've been a lawyer for almost 25 years. Almost all of that time focused on advocacy for children and families, particularly children in the foster care system. My goal in running for judge is to serve on family court and continue doing the same kind of work that's brought me so much satisfaction over the years. I think it would be a privilege to serve our children and families as a judge. One of the cases that I've been involved in that I'm most proud of involved a client I had who was a severely disabled little boy named Danny. Never lived a day of his life with his birth parents. Eventually was placed in foster care. Took 7 years for him to be adopted, which is wrong. No court process should take that long. And not only was I able to see him and his foster family through that process, but I was then able to successfully advocate for reforms that cut years off that legal process and are actually have been replicated around the state.
Same question.
Question.
Thank you. My name is Patrick Connolly. I've been practicing. I'm in my 19th year practicing. I practice primarily in the civil division. I'd say 85% of my practice is in the civil division. As far as the case that I'm most proud of, it's going to be tough to sum it up in a minute, but I'll try. I represented an individual. He was actually from Belfast in Northern Ireland, and he was assaulted in a bar on the south side. Again, very long story that went into this, but they denied responsibility. We ended up having to file a lawsuit. We did so, continued to deny liability. We went to verdict. We tried the case, jury trial. They returned a verdict of both compensatory and punitive damages against the bar, the bouncers that were responsible, that denied they were responsible. They wouldn't pay it. We had to start the execution process. It was a very long, drawn-out process. But what I'm most proud of, not just the successful result that we got, we ultimately were paid, but the case ultimately resulted in it's a published opinion from the Pennsylvania Superior Court on awarding of punitive damages against the corporation. So again, I'm proud that it was a successful result, but it was also, like I said, it is a precedential opinion now in the state of Pennsylvania. Sure.
Hi everyone, my name is Marcia Cooper, and I have been practicing law for the past 24 years after graduating from this institution. I have practiced in the civil division. I'm currently practicing in the juvenile family division, and I have practiced in the orphans court division. The only division I have not practiced in is the criminal division. I think if you were to ask me my most significant case, it would be actually a medical malpractice case, wherein we represented a little 5-year-old boy who was intubated improperly in Altoona and ended up with severe brain damage, non-functioning, blind. And we were able to secure a verdict for him that enabled him to live the rest of his life at the McGuire home. I don't know how many of you are familiar with the McGuire home, but it's a beautiful facility for handicapped children, where he remains today, and it receives really world-class care. And I'm really proud to be a part of that for him.
Hi, I'm Mark Daff. Oh, I thought you had a kill switch over there. Anyway, I'm Mark Daffner, and that's actually spelled M-A-R-C, not M-A-R-K. You just have to remember the last name. I've been practicing 20 years. My practice has been criminal, family, and commercial litigation, and I've practiced statewide in both state and federal court. As for the case that I'm most proud of, I should say that I'm most proud of today, because there have been many of them over the years. I represented the defendant in an appeal to the Third Circuit Court of Appeals in the very first case out of the Western District that held that President Obama's Fair Sentencing Act of 2010 could be applied retroactively, meaning applied to somebody that was found guilty or pled guilty prior to the passage of the act, but sentenced after the act. And that caused all sorts of problems, and it is now the law in the United States.
probably. That's probably.
Let's take it around the front.
Is that close enough?
Yeah, right, yeah.
Should I start?
Hi, my name's Barbara Ernsberger, and I have practiced in all divisions of the court, although my primary focus has been in the civil, family, and in the orphans court division. I've also practiced in the appellate courts and in the federal courts. I was trying to think of what would be my most significant case, and I decided to pick one out of the cluster of MetLife cases that my law firm tried. We represented 250 cases, which was 400 individuals, against the MetLife Insurance Company for fraudulent sale of life insurance and annuities. And we took those cases to trial. The whole project ranged from 1992 to 2007. So I'll pick one of those. I represented a widow who was 91 years old at the time of trial. At age 78, she had purchased many policies over the course of her life, those old industrial policies, and they had her converted. They persuaded her to buy one policy that would cover everything and give her all this money, the real purpose of which was to take her money. When she didn't pass the physical, they had her insure her oldest daughter, which means she had no coverage whatsoever, which I won that case and was able to reinstitute her 21 policies on all her family that they had collected. And we won 7 appellate victories, by the way. Any of you law students can find them that help consumers in Pennsylvania. Thank you.
Okay, my name is Marvin Liebes. I'm also a candidate for judge. Good afternoon, everyone. Thank everybody for coming here on a snowy day. Now, I've been an attorney for over 35 years, actually going on my 36th year. I specialize in criminal law, civil law, and bankruptcy, but I do cases in all divisions, and I do appellate work, and I do federal work. Now, it's hard to think of what your one case that your top was, but I did a case. The title was Jeffrey Sicarica versus Nationwide Insurance Company, where I sued the insurance company on behalf of the trustee in bankruptcy. And this case went up to the Third Circuit, and it was a presidential opinion. It was based on it was a good result. It was a presidential opinion based on when you can remove a case from. The case started in state court, moved to federal court, and this case is a presidential opinion in the Third Circuit on removal, and also everything else in the case. It's a 2004 case, and it's when I checked a month ago, it was cited everywhere for that. Thank you.
Good afternoon, everybody. My name is P.J. Murray. I am in my 25th year of practice, really 23 if you take away the 2 years I spent with a federal judge named Baron McCune as his law clerk. So I'm really in my 23rd year of actual private practice. I practice primarily in the civil division, although I've tried my share of criminal cases. Many of those go before magistrates, and they get resolved there. The one case I want to talk about today is one that I'm very proud of to have won in a very difficult set of circumstances. I represented a small business owner on a construction project, and he didn't get paid for his work. And we filed a claim and actually tried the case. And in that case, there was a counterclaim that was almost double what our claim was. So we were looking at, if we lost that case, a verdict or a judgment almost twice of what we were out, so of getting paid. And he turned to me at some point before the end of the case, and he asked me what was the potential, and I told him, and he said, if we lose this case, I'm out of business. And we won it, and so it's a happy ending. So.
Hi, I'm Richard Schubert. I've been in practice for 32 years. I'm in my 33rd year. I've been in private practice the entire time. Most of my work has been civil work. I have tried a case in orphans court, actually, and I've done a lot of different things, from medical malpractice to automobile accident claims. If I had to pick one case, and I can't pick one case, but if you force me, I'd have to tell you about a workers' compensation case I had. I represented 2 brothers, one for a long time and one for just one case. And the fellow that I represented on the one case was always unhappy. And, I think it was the financial strain of his situation. So we got a good result in his case. And about 6 months after the case resolved, the other brother called me up. And he said, Rich, he says, my family made me call you. I was going to call you anyway because we wanted to thank you. He says, you changed Mike's life. And I can't think of a better compliment from a client than to hear that his life changed for the better.
Hi, my name is Craig Stevens. I got admitted to practice in 1994 in Pennsylvania. I've also got admitted to practice in the state of New York in 2002, although I don't practice in New York. I have experience in the family division, the orphans division, and in the civil division. I'm currently an assistant county solicitor, so I have a broad range of experience in my job as a solicitor. I do a lot of different things. The one case or cases that stick out to me is in my duty as a solicitor, I handle child abuse expungement hearings for the Department of Public Welfare. That is when somebody is accused of abusing a child. Usually it's sexual or physical abuse. There's an investigation done by CYF, and then there's an indicated report if there's enough evidence to uphold that. Well, that individual then, their name is in the registry, and oftentimes they want to expunge their name when they want to try to get clearances. They then file what's known as an expungement proceeding to have their name removed, and they have a hearing. My job is to put a case on, and I'm proud of the fact that a lot of these cases have been upheld. These are children that are abused and so forth. Thank you.
Thank you all very much. Our second round of questions, we will begin with Mr. Leibowitz.
Okay.
And the question again will be addressed to everyone.
Fine.
And your question is, apart from Brown versus the Board of Education, what is your favorite U.S. Supreme Court case, as well as what is your least favorite and why?
Okay. My favorite, Brown versus Board of Education is one of my favorite cases, by the way. But I would say, my favorite case is the abortion case, where it made abortion a right under a right to have an abortion up to the second semester. The name of the case. My least favorite case is Dred Scott decision, which I think was totally mishandled, saying that slaves can't be moved from one state to another.
I will start with the least favorite case. I couldn't agree more. The Dred Scott decision is probably the biggest blight on our Supreme Court history. My favorite case is the Meritor Savings Bank case, which is the seminal case in the U.S. Supreme Court that dignified the claim of sexual harassment, which is very important in our jurisprudence today.
My least favorite case is a very recent case, Citizens United, which allowed corporations to try and dominate the political scenario in our country. My favorite case would probably be a very old case, Marbury versus Madison, where they established that the Supreme Court has the final word on everything in this country.
I'll have to concur with Rich. My favorite case is Marbury versus Madison as well. And my least favorite is the Dred Scott case mentioned by Mr. Murray.
And moving to the other side, Ms. Ernsberger, we'll start with you.
My least favorite case, I'm moving to the president of Citizens United, and I sort of fear the effect it may have on politics going forward, making a corporation same right as an individual. And I think that, I guess my most favorite case would be Roe v. Wade, protecting a woman's right to privacy. So I think that's the way I would end up with that.
Well, I would have to go with Roe v. Wade at the top and Dred Scott at the bottom. I think we've covered all the big ones here. So.
I think my favorite case would be Roe v. Wade. As a woman growing up in the 70s, I think it made a significant impact on my generation and my daughter's generations. I think my least favorite case would be Bush v. Gore, which I think gave us Citizens United.
That's a good answer. Could I steal that one? The least favorite? I think a very positive case this past year was the Affordable Health Care Act case that came out. I forget the actual name of it, but certainly that was significant, I think, positive, and the Citizens United and one that Marcia just mentioned was certainly at least on the scale.
I relate in part to the captions of the cases. So my favorite, both for caption and for principle, is Loving versus Virginia, which is the case that held state laws that prohibited interracial marriages to be unconstitutional. And my least favorite is Bush v. Gore. I detest the result of that case and also that my last name is in that case.
We will, this round, begin with Mr. Stevens and work this way. And given the number of you that mentioned Roe v. Wade, our next question is this. Pregnant women and girls under the age of 18 who do not choose or cannot involve their parents in their decision to terminate a pregnancy are forced to rely on a judge to determine their fate. Do you support the right of these women and girls to have a safe legal abortion? And part 2 of this question is there anything that would deter you from hearing these cases?
I think what you're referring to is a bypass hearing that the judge would perform, and obviously it would be a case-by-case basis, and I would weigh the facts. If the facts were supportive, I would certainly grant the request of the young woman to have the abortion. And I don't think there's anything that would preclude me from hearing these cases. I wouldn't be biased in any way. So.
I believe that such a decision involves the right of privacy of the individual and a matter of personal conscience. So I think what the law is looking at is the maturity of the person, the mental capacity of the person, and if those were adequate, then I would have no problem granting such a decision, and I have no personal opinions that would preclude me from doing my legal duty, which is to interpret the laws of this Commonwealth and this United States and enforcing them.
I'll start. I have no objection. Nothing in my personal background would forbid me from or preclude me from hearing those cases. And I think the bypass law, we have to read that, interpret it, but assuming that the case law and the facts of the case support the decision of the individual, it's an individual decision.
As a judge, I have to obviously look at the facts and hear the whole case, but I have nothing in my background to prevent me from hearing those cases, and assuming I would normally grant the bypass. I would have no problem with it.
And we will begin with Ms. Bush and work our way this way.
As has been mentioned, a bypass hearing is when a young woman who's pregnant comes before family court, which is where I've told you I'd like to be. The first question for the judge is whether she is a mature minor. If she is a mature minor, then what our Supreme Court has told us is that she has the right to choose. And I, first of all, have no difficulty in imagining myself presiding over those hearings. The second important piece, if she is not a mature minor, then the judge must decide, is it in her best interests for her to terminate the pregnancy? And there's nothing that would preclude me from deciding that type of a case either.
Yes, there's nothing that would prevent me from deciding that type of a case. I'm also satisfied. I understand in those situations there's a fairly extensive, I guess, educational process. I would describe it as that the minor has to undergo before even becoming before you. So I think that I certainly would be able to decide those cases.
There is nothing in my belief system that would preclude me from making a decision in that situation. I'm currently I'm a staff attorney with Kids Voice, and many of these young women are my clients. So in my capacity as either counsel or as guardian ad litem, I'm already required to counsel them. as to what their options are and work with them to try to determine what's in their best interest. So it's an area that I'm extremely comfortable in.
I'm the mic at this end. I'm not even going to use the mic. There's nothing in my background that would prevent me from ruling on a case like that. And let me add to something that Eleanor said, which is a correct rendition of the law. The initial threshold, of course, is whether the minor is mature enough, and that's in quotes, to make a decision. My personal feeling on this is that if a minor is approaching the court, has hired counsel, and has gone through an extensive colloquy, then they're almost presumptively mature, and the inquiry should end right there. So I would lean toward granting that in almost every case, unless it could be shown the person was immature for some reason.
We are going to stay on.
One more.
Oh, I'm sorry. I'm sorry.
I'll make it. I agree with the rest of my counsel. I have no personal prohibitions against applying the act, and I would apply the act as appropriate in each particular case.
I was all ready to throw the next question to you.
Okay.
We need to shift you guys down a bit because Marvin's not being on camera. And so we need to just move you a little tighter together.
We don't want that. We don't want
So
that to happen.
Just everybody move down.
Do we? Oh. You want to make sure Marvin.
I guess I can have my claim to fame there.
And move your name tag.
Oh.
Slide over and take your name tag with you. We're going to stay on this side of the table for now.
Nope. Okay now? Have you seen? Okay, thanks.
And Mr. Connolly, we'll start with you. And I would like you to tell us who your favorite U.S. Supreme Court justice is and why.
I guess this may not be a real popular answer, although it may coincide with my, thinking it's more recent history. I think Chief Justice Roberts made a very courageous decision with the Affordable Care Act, so I'll go with that for now. That works. And that's why, because of the decision he made this year, I think it was to cross party lines, so to speak.
And we'll move this way.
For me, it would be Sandra Day O'Connor. I think to be the first woman on the Supreme Court as a woman lawyer meant something. Waiting for the day where my daughters can see the first woman president. So that would be my answer.
Well, I actually like Scalia because the way he behaves causes all of us Democrats to really congregate and get together on our principles and our ideals.
I guess Ruth Bader Ginsburg for her positions on every case that I've read that she's been on. And I like Thurgood Marshall for all the work he did in civil rights before he got on the bench, and then his decisions when he was there. So I think that would be my two.
I like Justice Thurgood Marshall, just like Mr. Ernstberger did. He did all these great cases while he was an NAACP attorney. He argued Brown versus Board of Education, which changed everything. And once he got on the court, he made all these decisions for civil rights and privacy, and he helped change everything. He's my favorite justice.
I would have to say Bill Brennan. Justice Brennan had such courage, and he was such a good writer. And if you read his opinions, and he was so passionate about the way he wrote. So I don't always agree with maybe the result he reaches, but he certainly had passion, he had courage, and he was a great writer.
I would say Justice O'Connor as well, for being such a trailblazer as a female, justice, and doing as well as she did in law school, raising her kids. I think she really had the total package, so to speak.
William O. Douglas, longest-serving Supreme Court justice, and advanced more progressive opinions in this country at a time when we were in very great need of such an opinion from the Supreme Court.
I would say Thurgood Marshall because of his involvement in the civil rights movement.
While we give him a chance to catch up, we'll loop back around. Just so you know, the question on the table is, who is your favorite U.S. Supreme Court justice and why? But we won't force you to answer that right now. We'll come back to you in just a... Yeah, I'm just letting you...
I'm ready.
Okay, even better.
Yeah, I'm ready. I'm sorry. Let me catch my breath.
See? So we'll come back to you, Ms. Bush, and then we'll loop back and get Mr. Tranquilli.
My favorite of the moment is Sonia Sotomayor, who recently published an autobiography, and I had the opportunity to hear snippets of some of her interviews on the radio. Her life story is really inspiring to me. Her persistence and in elementary school, in college, throughout her career, and the perspective that she's brought to the court, I really appreciate.
And now, Mr. Tranquilli.
Yeah, I would say my favorite's always been Earl Warren, because Earl Warren was kind of an unpleasant surprise for Dwight Eisenhower. Eisenhower put him on the bench expecting him to sort of toe the party line and be very conservative, and instead Warren had the courage, I think, to break with a long series of Republican-appointed justices and chart new paths, and he changed the face of the court, I think, forever.
Very good. Our next question, and we will begin this round with Mr. Schubert. And we will then circle back around this way. So we'll go to your left. And Mr. Schubert, other than family members, who is the person you are most proud to have as a supporter, endorser in your present campaign?
Boy, I don't want to pick one. But proudest, probably my campaign chair, my former partner, and my friend Bill Caroselli. Why? He, when I first started with his firm, I was a young associate. I rose to become a partner in his firm. I was the managing partner the last 5 years at his firm, and I learned a lot of things from him, especially about doing things right.
I'd have to say my campaign chairman, Joseph Riley, is a friend from Scott Township. He's a constable. He's been involved. His involvement in law enforcement, and his service to the community. He had a business at one time, so I would have to say Mr. Riley.
I hate to fall into a track here, but my campaign manager, I would say, the head of my committee, Angie Galleretto. I don't know if everybody knows Angie or not, but she's the chair of the Wilkins Democratic Committee, and she's the longest-serving chair. She's the longest-serving committee person in Allegheny County, and most importantly, she sort of broke new ground and got into politics when it was just a man's game. And Angie had the strength and the courage and the quiet wisdom to sort of get in there, stick to her guns, bide her time until she could take a leading role in the party, which I believe she's done. I believe she's been a great example to people like Nancy Mills and Jeannie, who are strong Democrats as well.
We'll start here and work our way down. Ms. Ernford.
I would say Virginia Flaherty Cornyn, who has been driving me mercilessly forward in this campaign. Probably many of you know her. She's been active for a very long time in politics, and she's a real grassroots kind of person. And so I would say that's the person I admire the most.
I would say former Judge Livingstone Johnson, who was on the Court of Common Pleas for many, many years. He's always been supportive of my campaign. He's always talked very frankly about it. Has always been very encouraging.
I actually have three, so I'll keep it real short. I have been blessed in my career to have three really unbelievable mentors. The first being Bob Sindrich, who was a federal judge here in Pittsburgh, and then General Counsel, Jack McGinley, who I worked with, and then my father, Tom Cooper, all of whom are really just pillars of Pittsburgh legal community. And they have all three just stood beside me and supported me and encouraged me to do what I'm doing here today.
I would say, hopefully I'm not being too presumptuous, but I would say the 7th Ward Democratic Committee changed that. I'm a former member, and I've got to know everybody, and I've been very pleased with supporting the encouraging words since I made my decision, and so I'm thankful for that, and I'm proud of that.
The person who supported means the most to me is not an Allegheny County voter. Her name is Debbie Lane. She is a grandmother who lost custody of her grandchildren, who she had been raising since birth, to the foster care system in another county in the state. And after about 2 years of battling the system and getting no one to listen to her, a social worker friend of hers told her to call me, which she did. And I was able to help her and her lawyer succeed in getting the children back, and she has now adopted them. When she heard I was running for judge, she asked if how she could help. And she has been willing to share her family story and their photo, which some of you will see soon. And her support really means a lot to me.
And if memory serves me correctly.
Okay.
Yes.
I'm Marv Liebitz. It's hard. I have a lot of support. It's hard to pick one, but I have to pick one. I would have to pick Valerie Yockey. She's the chair of Plum, and she's also the chair of Valley Dems. What's significant about her is that the Valley was not considered an important part of Democratic politics, and she formed the organization with another person, and now it's a political force. And I think I'm really proud of her on that.
I would say the Pittsburgh Firefighters Local 1 union, and Joe King, Ralph Secura, and Darren Kelly. And the reason is they wrote me a letter, and in that letter they paid me probably the highest compliment I've ever received as a professional. And that is, words to the effect, we trust you to preside over cases that affect working class families in this county. Thank you.
For me, I would say the members of my campaign committee, about 65 committee chairs, elected officials, and members of local labor unions who have chosen to put their name behind mine, whose support means so much to me, and some of whom who have been with me since I started this journey in 2011. Hopefully will be there to finish it with me.
We will now move to the other side, and this time we will begin with Ms. Cooper. The statistics in Allegheny County show that arrests and convictions for drugs and driving under the influence account for the majority of cases, and there are mandatory sentences for all DUI and some drug cases, depending on weight. What is your thought on mandatory sentencing?
I am not a fan of mandatory sentencing. I think it takes the human element out of the judicial system. I think there are better ways to treat people with drug and alcohol issues than to throw them in jail. Now, some may need to go to jail, but I don't think that's everyone. And I think you really need to take it on a case-to-case basis. And as a practical matter, I think we waste a lot of public resources imprisoning people as opposed to giving them help. And so I think at the outset, people should be are given an opportunity for help before we rush to incarcerate them.
And we'll continue to the right. We'll move on to the right. Yeah.
I don't think you'll find any judge who would be supportive of mandatory minimums taking the discretion away from that. So I would say certainly as a judge you would not be supportive. And I would agree with you. It's that you're standing before somebody or someone's standing before you. You want to have a little bit of discretion of your own. So I would say.
I'm not a supporter of mandatory sentences. I learned, though, when I studied sentencing in law school from one of the nation's experts on sentencing policy, that sentencing guidelines are very important for a justice system. Before we had systems that included guidelines for sentencing, you could have completely disparate sentences for the same crimes depending on where you were. Justice by geography, no good. So to my mind, what makes most sense is a system that gives ranges, guidelines, that a judge has the discretion to depart from either up or down based on individual circumstances.
And we will continue, just make a full circle. Mr. Tranquilli?
Yeah, working at the DA's office, we've created some specialty courts. We have DUI court, we have drug court, we have veterans court, we have mental health court, and I think that reflects, the mentality that we've developed as prosecutors, at least for the 20 years that I've been in the DA's office, that, you need to have specialized courts for specialized problems. I mean, people don't commit crimes for no reason. A lot of them, they have fundamental, at the root cause, they have alcohol or drug dependency, and I think by and large those courts are moving in the right direction. I'm not in favor of mandatory sentencing because I think it takes away the individual element. As Ms. Bush indicated, however, we all have to be on the same page. We have to be constrained at least by the same ranges. That's why we have a mitigated range, a standard range, and an aggravated range for every crime on a grid based on the person's prior record and on the offense gravity score or the severity of the crime that's committed. So I think that within those confines, that's a pretty safe bet. I think we can still get the standardization there.
I'm not in favor of mandatory sentencing either. I concur with my colleagues. I think there should be a guideline system in place to give a judge some discretion. I think it's a case by case under the circumstances how a person will be sentenced. If they're a repeat offender, obviously, that's something that would be considered. There are programs in place. There's the Renewal Center, the program for female offenders that address some of the overcrowding and some of the lesser offenses for drugs and alcohol and so forth. And there are programs to help reach out to these folks so they don't become repeat offenders. Thank you.
I don't believe in mandatory sentencing, and I think that even with guidelines, I think judges should be permitted to deviate from those up or down depending on their individual discretion and the facts of the case. I agree that the specialty courts are necessary to address the root problem of the individual perpetrators so that we cure them so they're not back in the system again, and to the extent possible, help them move on to be in a better part of their life.
I agree that the sentence needs to be tailored to the individual, and of course if the judge is departing from the guidelines, that there should be a good, clear reason stated therefore, but that the best sentence is one tailored to the individual.
I don't believe in mandatory sentencing, but the judge's belief isn't what rules the day. It's what the law and the legislator wrote. Unfortunately, these mandatory sentencing laws are the laws, and judges have obligations to enforce the laws. Whether you're a fan or not a fan, you have to interpret the law as it's written.
I'm against mandatory sentence. I think that a judge, after he hears all the facts, should be able to make a decision as to the sentence. And I do agree, we do have sentencing guidelines, and as Mr. Tranquilli said, and if the judge wants to deviate, he can deviate from it. Now, the problem I have with mandatory sentencing is most of the time, a mandatory really isn't a mandatory because a district attorney can waive the mandatory usually. And what happens is that you're faced with a case. I'm a criminal defense attorney. I do a lot of criminal defense. You're faced with a district like in a drug case telling you that there's a 3-year mandatory. If you want to try it, I'm going to go for 3 years. But if you want to plea, I'll give you 11 after 23 months. And I think that's improper because it's forcing the person to plead guilty to something that he really should have a trial. So I think mandatory sentences are bad. But I agree with my colleague that as a judge, I have to interpret the law, and whatever the legislature passed, I have to follow.
Our next round of questioning will begin. Oh, I'm sorry. Wow, that's the downside. Sitting right next to me. I'm sorry.
I don't believe in mandatory sentencing, and I think that it removes the discretion from the court. I understand a need to regularize what decisions are so there's some consistency, but I do not believe in mandatory sentencing. I'll apply the laws the legislature provides us with it, but I wish somebody would go to the legislature and talk to them.
I've actually dealt with this issue head on, and I've opposed mandatories in federal court in cases like U.S. versus Hamlin, U.S. versus Mangan. Those are some cases that I've had. I've dealt with it in the context of bringing people back from prison for resentencing post-Booker. And you can't really say as a judge that you don't believe in mandatory sentences because they're there. There's something to, you have to believe in them and you have to apply them. I think the DA's office has done a very good job of putting together some diversionary dispositions that can help people avoid that. And unfortunately, no judge wants to not have discretion, but mandatory sentences have to be applied. And that's really a legislative issue.
Our next question, our next round of questions will begin with Mr. Murray. Approximately 95% of criminal convictions are obtained by guilty plea, rather than bringing a case to trial and a guilty verdict. Much of this phenomena is often attributed to prosecutors overcharging the cases, making it far too risky to plead not guilty even where the facts may not support a guilty verdict. Do you think it would be beneficial to have more questionable cases brought to trial rather than resolved by guilty pleas? If so, what would you do to discourage overcharging by prosecutors?
Well, first of all, I think the right to jury is paramount. The right to have your case heard by a jury of your peers is a fundamental right we have in this country. If the defendant believes that the case should be determined by a jury, that's his or her right. I certainly believe in that. I don't, of course, would abhor overcharging somebody for something that to get a conviction. That's wrong, and I don't think that should ever happen. So I'm not in favor of that. The question was a long one. I may have forgotten, but I don't believe prosecutors should overcharge to get convictions, and I think people should try their case to verdict if they believe in their innocence.
Okay, we're going to go this direction so that I don't make the same mistake.
Okay.
Yes.
All right. Like I said before, I do a significant amount of criminal defense. I think I am a great believer in the jury system, and I would never, ever, using that song, I would never, ever tell any of my clients to plead guilty if they didn't do it. I mean, if a person really claimed their innocence, I would take it to trial. I mean, no matter what. But the plea system is a good system, though, because a typical day, if you go to a typical common pleas judge criminal division, they may have 12 cases, and at the most, one will go to trial. If every case went to trial, the system would collapse. We would need, well, of course, when we have bad, we'd have to have 100 judges, which wouldn't be bad. I have a better chance of getting the job, but it wouldn't, for taxpayers, wouldn't want to say. You would have to have instead of, I think there's, I don't know how many divisions, I think there's like 15 judges in criminal. You'd have to have 100 judges in criminal division. You have to pay more for jury trials. I think that not having the police system would destroy the system. That's my belief.
Ms. Arnsberger.
Well, it sounds from the question as though they're overcharging as a form of intimidation. I think that's where your discretion as a judge comes in, and you say, to the prosecuting attorney, don't you think you're overdoing it here? I mean, you raise it with them before it proceeds further. I don't approve of something like that. I understand there's a great need because of the volume to push the system along, but you're really there to individually deal with each accused person and their rights, and you should not be. They should not be doing that. So they would have a hard time getting that past me if I understood what they were doing. That's all.
Well, I think the overcharging is really an accepted part of life in the criminal division of the court. I mean, this happens. And you can chip away some of that at the preliminary hearing. At the end of the day, if an individual wants to take responsibility and plead guilty for something they did, usually you will find the prosecutor is reasonable. In instances where a prosecutor is unreasonable and will not back off to anything that's acceptable to your client, then you go to trial and you'll find that more often than not, you're getting a not guilty verdict. For 20 years I've experienced that. So really, and the DA's office is very good also about working with you. Unless there's an individual DA that has a vendetta, and I don't see any of those particular people in this room, you will work things out. And the stop loss is the jury trial system.
I think for the same reason the last question talked about judicial discretion, I think a prosecutor has prosecutorial discretion, and you can't take that away from them. I just believe, and I've seen it in my own trial work, that the system has a way of equalizing, and that juries get it. And so the danger for a prosecutor who overcharges with an innocent defendant is the jury's going to see that. They're going to get it. So I have great faith in juries and the system to balance out what may be inequities at the outset.
I don't disagree that there's some element of overcharging that goes on, but I think that's just, I don't know that there's a relationship between the overcharging and the element 95% plea bargains if that's the case. I think ultimately in a case the facts bear themselves out and the client is faced with a deal and they can choose to accept it or not. And again, there's always the option to go to trial. So I just don't think there's a relation between the overcharging and the plea bargain. I think plea bargains are often done because they feel it's in their best interest.
I think this question is in part a question about resources, because it's been pointed out already. If we didn't have the number of guilty pleas that we get in the criminal justice system, if more people insisted on going to trial, the system would fall apart. So I think there's a resource question there that is worth thinking about further. What I will also tell you, I told you already, my expertise is in family law, children and families, and I think it is really important for a judge and a lawyer not to opine on things they don't know a whole lot about. And so what I would say to you is, I would look into this question further before giving you an opinion today on what should be done.
Mr. Tranquilli.
Well, I'm gonna sort of break ranks here. I'm going to challenge the underpinnings of this question. I'll be honest with you. I don't know where the statistics are coming from, but I know that in Alameda County during my 20-year tenure, I've seen very few incidents of overcharging by the prosecutor. You have to remember that the people that get the first crack at defendants are the police. The police charge whatever they want to. Then the prosecutor steps in and represents the case in front of a district justice. That district justice decides whether the case has been overcharged or not. And that district justice decides whether there's enough evidence to continue with all the charges or only some of the charges. So there's a safeguard built in there. For example, if you have a bar fight and somebody cracks somebody upside the head with a beer bottle and it cuts their head open, you can charge that as aggravated assault. It's also simple assault. Which one is it? It's up to the 12 people that ultimately hear the jury case. Okay? There are many cases like that. The difference between burglary and criminal trespass is just a question of intent, and the jury has to decide. As a judge, I can tell you I would not accept the plea unless a defendant told me absolutely after a colloquy that he was guilty of the crime he was pleading guilty to.
I'll just follow up with that. I don't do a lot of work in the criminal division, but in the family division, juvenile court, there is a colloquy for a guilty plea for a juvenile, and assuming that would be the case in a criminal court proceeding, for an adult, I would be careful and make sure the person understood their rights and knew what they were pleading to, and there was a proper colloquy. These individuals are represented. They do have defense counsel. And if they don't want to accept the plea, they have every right to go to a trial and let their peers make the decision. I certainly wouldn't encourage any overcharging as a judge. But it's a process, and they're entitled to their rights. And it's also for the sake of resources. It's been mentioned by a couple of my colleagues that If we didn't have all of these police, we would have, the system would be overcrowded. We would have backlog. So it has some beneficial purpose. And of course, the victims' families would have to be obviously they're consulted as well, and it saves them the trouble of having a trial, going through some hearing of the facts of the case. Thank you.
I have to disagree with Mark somewhat. I don't think district justices have that much discretion in eliminating the cases. All that you have to show is a bare prima facie case for these charges, but I think the trial judge has to have the same reflection as the charges are brought to the common pleas court. I think that a judge has been referred to in a number of areas, expert witnesses and so forth, as a gatekeeper. I think the judge has to work as a gatekeeper on the charging, and if the charges are not warranted when it gets to the trial court level, I think the judge has to have the conviction to dismiss those charges.
My practice is exclusively criminal defense work, and I will say that I agree with Mr. Tranquilli that I think that our district attorney's office does an excellent job of not overcharging. In fact, overcharging to force a plea, I think, is prosecutorial misconduct. It's not something that happens. Of course, the magisterial district justice has the authority to throw the case out completely, but there are many safeguards along the way. I think part of the question at the end, and I don't really remember it, I think it said something about what can a judge do to keep this overcharging from happening.
Yes, it is. What would you do to discourage overcharging?
Discourage overcharging. And I would say two things. Number one, when they're answering the guilty plea colloquy, there is a question, are you pleading guilty because you are? And if they are not answering yes to that, the judge should not accept the plea. And secondly, I think it's important to start using the pretrial conference as more than just like a perfunctory date. And I think really having a pretrial conference instead of just picking dates, sort of getting down to the paring down the charges to what's absolutely appropriate. But like I said, I don't think it's an issue with our county's district attorney's office.
Okay. Our next round of questioning is going to begin with Barbara Ernsberger. And this is a question about civil division. And this is a multiple tiered question, so if you need me to go back over any portion of it, I'll be happy to. Banks, insurance companies, brokerage houses, and the like are mandating that as a condition of a consumer maintaining an account with them, the consumer must waive his or her right to a jury trial, be bound by arbitration as the sole means of dispute resolution, and waive the right to initiate a class action. 3 questions with respect to this development. What is your opinion of this practice? Would you as a judge be willing to apply doctrines such as contract of adhesion or unconscionability to avoid such provisions? And 3, if your answer to B is negative, why not?
All right, that's a very complicated question. Let's start with that. And because I've dealt with a lot of consumer fraud, so I'll start off with this. I have seen those kinds of provisions, and they're doing that at nursing homes, by the way. They pass them around for people to agree that everything goes to arbitration if they have a complaint. I always tell anyone that brings it to me not to sign it because I think they're waiving far too much and they don't understand what they're doing. They're waiving the right to go to jury trial, and also have their cases heard by a court and the right of discovery that comes along with civil division cases. So I would think that's a very bad idea. I think that in many cases, those provisions, especially when it comes to terms of finance, are going to be in tiny, tiny print somewhere, and people are not going to even understand what they're doing. So I suspect there would be good reasons and ways to set it aside. You are, by the way, not required, we won the case, you're not required to read an insurance policy when you buy it in this state, in case you're interested. That's under PA, because we won that case in PA consumer law. So I would be willing to, I would want to hear what the person thought they were doing and how it was explained to them at the time of whenever they signed up for whatever, anything that they did. And what was the rest of the case there? There were some more parts to that.
What is your opinion? Would you as a judge be willing to apply doctrines such as contract of adhesion or unconscionability to avoid such provisions? And if your answer to B is negative, why not?
I would be, you've missed some, whoever wrote that missed some provisions that could be provided, but I mean, they're probably all contracts of adhesions, I'll tell you that right off the top of my head, and I'd be willing to look at that, but you also have a lot of rights under the Consumer Protection Act if it's done at the time of sale. I think people should look at that for these kinds of, those types of activities, and as a judge, I'd be more than willing to look at it, and I think the insurance industry would hate to have me sitting there, but that's beside the point. Because I tried too much of this stuff, they would know I was alert to their problems. Go ahead.
Well, I've dealt with that in the consumer rights context, and usually these clauses actually say that any dispute of these terms must be brought to arbitration. It doesn't bind one or the other. It theoretically binds both. But, you know, the problem is these creditors and these companies, they don't even abide by it. They'll go and they'll sue a consumer faster than anything. I've used those clauses to get things thrown out of common pleas court, and it's never been followed up on by the company after that. So, you know, it can actually work that way on the defense end, too. You know, I don't think they're ever enforced. I think, you know, you'd have a good forum non-convenience argument there. And as Barbara said, you know, at least on the insurance end, you don't even have to read the thing. So, sure, contracts of adhesion can apply, you know, as can defenses under, for example, the Retail Sale Installment Contract Act, you know, the Fair Credit Extension Uniformity Act, and all sorts of other state and federal statutes. So what I'm sort of saying, I guess, is that your question doesn't matter that much at the end of the day.
I spent a large chunk of my career suing insurance companies and banks and other big entities. I do believe, you see them all the time in agreements, and they're becoming more prevalent. And they're the contracts we all get and nobody reads. Guilty here. So while I do think it is a contract of adhesion, because you don't really have a choice. If you want the service or you want to work with that provider. I don't think, as my memory at least, of the current law is that it supports a binding of a contract of adhesion. I think you have to go different routes, like through the consumer protection law, and those things to be able to overturn a contract along those lines.
Yeah, I think the question was basically, would you be willing to apply those legal doctrines? And certainly the facts supported in the North, absolutely. The other side of that is that sometimes those types of clauses are meant for alternative dispute resolution, and sometimes they're actually beneficial to the consumer. They're more cost effective, but not always. It depends. You know, perhaps you like to see, you see them oftentimes where they say if both parties agree, we'll agree to resolve this issue outside of the court system. If both parties agree, again, a lot of times it's done much cheaper. But I certainly think that people have a right to be careful of waiving that right.
I think the question envisions manipulative practices that are taking advantage of people who either don't have a choice or don't understand what they're signing. And part of the reason why we have courts is to correct injustices. As a judge, I would use whatever legal tools were available to me, including the doctrines mentioned, to correct injustices if that's what was happening.
Mr. Tranquilli.
You know, 20 years ago, when I started in the DA's office, we had trouble keeping jurors over in the criminal division because there were so many jury trials being picked over in the civil division that they kept cleaning us out. And that has eroded over the last 20 years, noticeably. So much so that at one point our county executive proposed to eliminate 2 of the 4 seats that all of us are seeking right now because the civil division hasn't seen the kind of volume in jury trials that it used to have. I personally don't think that's a good thing. You know, I think there's no problem with setting a dollar amount, you know, on a jury trial. But I think that at the end of the day, People don't read a lot of these contracts. Who has time to sit down and read a 7-page contract with tiny print without an attorney standing beside them looking over their shoulder? And, you know, at the end of the day, if somebody wants a jury trial and the dollar amount is worthwhile so that the public resources are not being wasted, then I say let them have a jury trial and trust to the common sense of the common man, 12 people that are sitting in the box.
Yeah, and I think if it gets to the level of a judge, first of all, I would certainly apply any remedies that were available and any of the contract remedies that the doctrines that we mentioned. You know, and I concur with Mark, a lot of these documents, you know, you're signing and some of this stuff is buried in fine print and you don't realize, you know, you may not be required to read it, but you still, you don't realize you're signing away your rights. And so if it gets to a point where it's a matter before a judge, I would certainly, the person should be entitled to adequate remedies under the law. And I think a couple of my colleagues mentioned that consumers do have rights and protections as well to follow up on. Thank you.
There's been a series of cases involving pre-activity waivers, such as skiing, snowboarding, where you waive your rights to collect. And the Superior and Supreme Court cases in Pennsylvania have watered those down, that you would have to show a knowing and intelligent waiver of the specific danger that was involved. And a lot of those waivers have been voided. I essentially would apply the same standard to these contracts as is applied to the Miranda test. Is it a knowing, intelligent, and voluntary waiver of the right? And did the person know they had a right to counsel? As far as my opinion of the institutions that try to impose these on consumers, I can't say it because I'm being videotaped, but if you would like to know my real opinion, just say I detest them.
I think the first part of the question about, you know, what is my opinion of this practice? And I think you referenced specifically being bound to arbitration. And arbitration really is a wonderful tool, I think, that in many circumstances, I serve as an arbitrator in the civil division. It can really save the courts a lot of time and a lot of money. But in terms of, like, what comes to mind is the recent Carnival Cruise debacle, where they said there weren't going to be a lot of lawsuits because they'd have to travel to some, you know, unreachable location to file suit or something like that. I mean, there are provisions in the law to protect consumers if their, you know, waiver isn't made intelligently. My willingness to apply doctrines to avoid such provisions, any that are applicable, would have to be decided on a case-by-case basis.
I would say that we're dealing with the interpretation of a contract here, and basic tenet of contract law is what is the intent of the parties when they entered into the contract. So the first thing as a judge you have to figure out, if somebody comes and says, look, I don't want to be in arbitration and what I signed requires me to do that, you would figure out by evidence, by testimony, what was your intent when you signed it. Did you intend to sign away the right to a jury trial? Because I said earlier, the right to a jury is a fundamental right we all have in this country. Be it in civil law, criminal law, or whatever, you have that right. So the first issue is, did you intend to waive that? The other part of contract law is, in this country, parties have the right to enter into any contract generally that they want to, as long as there's agreement, and they intend to be bound by the terms of it, and it can be oral or written. So to me, the analysis is, did you intend or want to be or have no problem entering into that, and if not, why not, and what are the circumstances surrounding that? And I would have no problem voiding that contract if in fact the intent was never to enter into it.
I am personally opposed to having those provisions in the contract stating they can't have a jury trial, because I believe, as Mr. Murray said, I think the right to a jury is a fundamental right, not only in criminal cases and in civil cases. But on the other hand, as a judge, I can't follow my own personal beliefs. I have to look at the facts and give a fair hearing. And I'd have to have, if an attorney came to me presented his argument, I would look at I want to present the facts of the hearing. I want to brief, see what the case law is in Pennsylvania on this. But without looking at that, I would have to see what the intent is. Was there a knowing, intelligent waiver? Did the person read the contract? I know, because most of those things are little provisions of fine print. I know my clients, when they're signing documents in my office, they 90% of the time, they don't even read it. They just say, I trust you, Marvin, I'll sign it. And I know that for insurance companies, I'm sure they do the same thing. So I would consider those remedies, but I would want to have a complete hearing and have briefing and then make a fair finding effect of both sides.
Thank you all. Our next round of questioning will begin with Ms. Sadler. Do you believe that insurance and other propaganda is affecting jury verdicts in Allegheny County? If your answer is in the negative, why not? And if so, do you have any ideas as to how to counteract it during the jury instruction phase of a civil trial? Would you be willing to entertain a point for jury charge to counteract it? If not, why not?
Okay, you said insurance and other, what was the second word?
Propaganda is affecting jury verdicts in Allegheny County.
Okay. You know, I don't, as I said, the extent of my practice is criminal defense. I don't, you know, you can't even really so much as mention insurance in a lot of these cases, you know, relating in the civil division. So I don't know that it's necessarily a problem. How to counteract in a jury trial, I think that any jury instruction that is warranted, that would be curative, would be appropriate. Mr. Schubert?
Yes.
There is a definite effect. When I was president of the trial lawyers, we did a study. This began in the late 1980s with the propaganda insurance companies were putting out, and it has affected the verdicts in Allegheny County. Do I think the jury instruction is sufficient? No. It's you have to do it in voir dire, where you question the jurors. We have to have open voir dire where we can ask the jurors if they have seen any of this garbage and if they believe it. And I think it permeates our system the way that has been out there for over 20 years.
And I would concur with Mr. Schubert. I think that during voir dire, you can find out if there's any prejudice on behalf of any potential jurors, if they've been affected by this issue, and if that's the case, then they should be excluded from the jury pool. As far as any charge to the jury, obviously, as a judge, you would charge them accordingly and then ask them to discount anything that is not related to the facts presented during the trial when they're deliberating for making their decision. Thank you.
I'm absolutely in no position to judge what effect insurance companies or propaganda has had on these civil cases. My practice has been exclusively in the criminal division for the last 20 years. The closest thing we have to it is we see jurors with expectations that are so high because of television shows like CSI and these true crime dramas. And we do take steps when we're picking juries to address these issues with jurors who have these unreasonable expectations. But as far as the effect of the civil division, it's simply out of my area of expertise.
Ms. Bush?
I will echo that, although from a different area of expertise. I don't have an opinion on the effect on jury verdicts in the civil division. I will say that the suggestions that have been made by my colleagues about examining jurors before they're placed on the jury sound very useful.
My understanding, and perhaps members of the witness bar, Richard and Barbara could answer this. I've had a lot of discussion. I mean, my understanding is that they feel that not the propaganda in the insurance industry, for example, the Edgar commercials and things like that, have done much to negatively affect the jury's opinions on those types of cases. And that's my understanding. I haven't done a study myself, but that's one way. As far as the voir dire, in those cases, those are types of cases that I tried. I interviewed countless juries on that, and they are vetted. I mean, you're asked to determine, do you have an opinion on civil damage lawsuits? What is that opinion? What have you heard? And they are vetted in that sense. So I think as far as the jury's going, you have an idea of what they're thinking, what they're selecting.
I definitely think it's had an effect. I think there are two effects. I think one is that in so many areas of plaintiff's personal injury, you can no longer put medical bills before a jury. So all you can do is talk about pain and suffering, and it's so nebulous that, you know, how do you define that? You don't have any hard numbers to work off. So I think that's the legal end of it. I do think the sort of campaign or propaganda, as Rich said, did begin in the 80s, when you started seeing billboards saying, you know, insurance fraud is a crime. And doctors talking about how, because of their malpractice rates, they're all fleeing the state. So I think there was a concerted effort to make jurors skeptical. And I think we have hurt ourselves through legal advertising to some degree, because now it portrays to the public that if you bring a personal injury suit, you're playing the lottery. You know, you're not paying any fees, you have no skin in the game, so you're just taking a chance. And I think that has come back to not to benefit us, because it's made jurors skeptical, and it's made them you know, not want to be sympathetic or empathetic to the client.
Yeah, I think it's absolutely affected civil verdicts in Allegheny County. I think most civil division judges will tell you that. The problem is really that it's been so pervasive for so long that, you know, we have to almost accept that as a given, that your jury pool may somehow be prejudiced, and you have to deal with that in jury selection. I don't know that an instruction would necessarily be appropriate unless it was alleged that a juror made an inappropriate comment, or if an inappropriate question leaning toward that way was directed to the court. I think then you'd have to give a curative instruction. But the time to deal with that issue and try to hand it off is during the jury selection process.
The jury selection process in this county is very weak. You don't get to actually do the kind of voir dire that is permitted in many other states. Therefore, you don't get to ask the questions that you can really pull forward. There are people actually on jury pools now come in with an agenda which they conceal and will not openly reveal to you. And you only find it out, I mean, accidentally or not at all. And so they come in with the thought process of this person who's filed suit should not be here and isn't entitled to an award without hearing anything. And all of this has been created by decades of advertising and millions of dollars put into the advertising. It's all that we found that was very specific. The cases that we tried against for life insurance fraud haven't been advertised against. So the juries didn't have the same agenda that they would have had in an automobile case. I found that out because you're allowed to talk to jurors after they come to their decisions, and I would start finding out what they were doing. But it's really an outrage what has happened, and it has affected everything that can go on for people who suffer any kind of an injury. It's almost like we return to the days of when if you're an injured person, you must be, there was an old-fashioned biblical concept, if you were ill or sick or injured, that you were evil or something. It's almost, that concept has almost come about now. It's become very hard to communicate the sufferings and the problems of people who have suffered injury. So, I don't know, the civil division really has a problem to deal with. I don't think we deal with it adequately in this county at all. Right.
I believe, I've been practicing law for 35 years, and I'm certain that the impact of propaganda saying that insurance fraud, seeing it over on the screen, has had a huge effect. When I started practicing, I didn't have to go to a jury. I got settlements with the claims adjusters. Now they don't want to settle. It seems like everything, a lot of things are going to juries. But more important, it's not only the propaganda, it's the legislature by passing the limited tort. Because 90% of the people who come to me have limited tort, and under that statute, you have to show severe injury to get pain and suffering, which destroys most of your cases. Now, as a judge, I think I agree with Mr. Schubert. I think a voir dire would be the best way to try to solve it. Now, if the attorneys have an instruction they want to propose to me, I'll look at it and see if it would help. And I don't know if there's any would help, but I think I agree with Ms. Ernsberger that the system for injured people is very poor in this county, in the state too, I think.
I don't know much about propaganda, but I do know this much. Recently, we had a $109 million verdict in this county. And so I don't know how propaganda affected that. But, and I can tell you also, in West Virginia where I practice, there are a number of large jury verdicts there. So maybe our propaganda in this state is different than the propaganda in other states. I don't know. I'm no expert on propaganda. I haven't done any studies on it. I do know this much. I have written jury instructions when I worked for Judge McCune, and I've tried cases where the following jury instructions have been given, and that is jurors are to bring with them their common sense, and they're to follow the evidence that's been presented in the trial. So, you know, in the voir dire, and I've been called as a juror as well, and I know that the voir dire tries to ferret out from your obligation as a juror any prejudices from insurance companies and the like. So what effect propaganda has, I don't know, but I can tell you that jurors should be and are instructed to bring with them their common sense and to follow the evidence that's been presented. Maybe there's a problem with how the evidence is presented sometimes, as opposed to what the propaganda effect is.
Mr. Daphna, according to my notes, you have not led the questioning off. Is that correct?
That is correct.
Good. Then the next question is yours.
Okay.
Judges of the Courts of Common Pleas are elected by the people and must stand for retention every 10 years. However, the practice has developed whereby judges who reach the age of 70 take senior status. The idea was that senior judges would be available to help out as need arises. However, several senior judges work full-time in positions of great authority and control in the Court of Common Pleas. In effect, bypassing the requirement of standing for a retention election and denying elected judges their opportunities to fill these positions. What is your view of this practice? And if you're opposed to it, what would you be willing to do to stop it?
Well, I think, number one, I think there's already a bill in the legislature to expand the age to 75. These judges that are still there after age 70 and they're working as senior judges, they already have to leave when they're 80. That's also the law. They can't sit there, until they're 1,000 years old like they used to be. And really what we need to remember is they're doing nothing more than adhering to the law as it's written. They're allowed to do that. They're paid per diem. They can come in, they can handle as large or as small a caseload as they pick and choose, I mean, we're talking about a legislative issue here also. And I don't believe that them just being there takes away any vacancies that would be created on the court. They're doing extra work, but we have a huge backlog of cases in Allegheny County too. I think by and large the attorneys appreciate the additional help. I know we certainly do, and it doesn't prevent other judges from being elected or from doing work because it doesn't count against any vacancies.
Ms. Ernsberger, we'll go this way. We'll go counter this time.
Well, the mandatory retirement age of age 70 seems somewhat out of date. Many people are working, my mother's 88 and she runs a business, so many people are working much later in their lives. It's actually written into the state constitution, so they filed a lawsuit in Philadelphia to overturn it, but they may have to do it legislatively. So, but be that as it may, the practice of senior judges I found to be helpful rather than harmful because they seem to be able to fill in and know what's going on for judges who are on vacations or when there's a case overload. I think if they extend the age of retirement, then at some point they're going to have to decide how you get judges off the bench who should be going for health reasons. Of course, that can happen long before you're 70 too. So. But that has to be another issue that's addressed. But generally, I find the senior judge practice to be helpful more than anything else.
I think that the requirement of mandatory retirement at 70 is unfair. No other state employee has that requirement. It violates violates the discrimination in age. I don't see any basis as to why judges have to retire at age 70. Now, assuming that's the law, though, I don't have any problem with senior judges. I think they help out. They reduce the backlog. And, a good example, Judge Gallo does the summary appeals, and he does a great job. He manages that courtroom. He does all this. The summary cases are considered minor cases. Criminal cases are divided into felonies, misdemeanors, and summaries. And he does all the summary appeals. And so I think he does a good function, and a lot of senior judges do. And we had Judge Reed in Criminal Division come from Beaver County and helped us a lot. And I think the senior judges do a lot, and they're not, those slots aren't counted as like the 4 vacancies we have. Those people, they don't count as vacancies in the courts. They're not hurting our abilities to get hired or retained.
I don't think the mandatory retirement age at 70 is being used to bypass the retention of judges. In the history of Allegheny County, there isn't, in the Court of Common Pleas, there has not been one judge that has not been retained. So it's not a long shot on retention. With respect to the mandatory retirement age, I think the Supreme Court of the United States has ruled on that, and I think one of the parties was Ashcroft. A state court judge case out of Missouri. I don't know if it was John Ashcroft or that just happened to be the judge's name. I can't recall. But the Supreme Court of the United States has already ruled on that issue and has ruled that mandatory retirement for judges at age 70 is certainly lawful. But I do agree with senior judges that are capable and want to work and continue to work, that they should be able to help with the overflow. I'm definitely in favor of that.
Yeah, I don't think the question is about how old should these people be or not. I think their question was about, does it in effect bypass the requirement of standing for retention? And I don't think that's necessarily the case, and it doesn't apply, the senior judges, as I think Marvin said, don't count toward the vacancies. I think the senior judges are very helpful. They take down the caseload for everyone else. I think I'm the only person here that could serve 3 full terms and then some. I like to think by that time I would know enough about the judiciary to be even more helpful than I was in the beginning of my service. So I think senior judges are helpful in that regard.
I think the question was senior judges working full-time, taking the place of other judges. What you have to understand is that if the judges are working full-time, they're doing a lot of that without pay. The Pennsylvania Code provides that the senior judges can get a per diem, a daily stipend, but combined with their retirement benefits and their stipends that they get, they cannot exceed the salary of a then sitting judge. So knowing what the stipend is and what the for example, if you had a judge who's been there 20 years, he could be getting close to the full salary. So, in essence, he wouldn't be getting much of a stipend. He might get 2 or 3 days a month, and then he's done. She's done. I don't think they should be used as full-time judges. I think that they do serve a purpose and that they can be helpful with the court, but I don't think that they should be working full-time, even if it's gratis. If we need more judges, we should have more judges.
And just to start off, I don't think there's much impact on retention. I think, as PJ mentioned, I don't think that's an issue because of the retention rates for judges. The retirement age at 70, I think that's an issue that's been litigated. I think somebody mentioned there is a bill pending in the legislature, and I think there was a suit filed coming out of Philadelphia. So that issue will have to work itself out as far as whether the mandatory retirement age of 70 is going to change. I think senior judges do provide some benefit. A couple that I can think of, I know in the family division, Judge Kelly helps out when the commission judges are away on conferences and so forth. They use him to help. I know Judge Weddick is in the civil division. I know he hears the motions on Fridays, and I know a lot of attorneys rely on him and his knowledge in handling those. Judge Gallo was mentioned for the summary appeal. So I think that the senior judges do provide some benefit, but I concur with Mr. Schubert. I don't think they should be at a full-time status as a commission judge, but I do think they serve some purpose. And I think my time's up. Thank you.
I think I agree mostly with P.J. Murray on this. It's not a question of retention at all. That retention is kind of a joke. There's never been anybody that hasn't gotten retention, and that's a debate for another day, frankly. With regards to senior judges, I have a little bit of a different idea. I really don't think senior judges are the greatest greatest idea in the world. You know, because whether you're in the civil division or whether you're in the criminal division or the family division, wherever, I mean, you're dealing with the most important issues that are going to affect a citizen's life off the street. I mean, in the criminal division, our senior judges still hear bench trials. They don't do jury trials anymore, but they do bench trials. They're still deciding on people's liberty. You know, in the civil division, the family division, they're still making decisions about critical issues. And, you know, I'm sorry, I think at some point you have to draw a line in the sand as far as the age. You know, and at 70, I think most people at 70 still have great faculties, but I think it's better to be safe than sorry. If you need more judges, get more judges. Let people enjoy their retirements. I know after 24 years, I'd be ready.
Yes.
I agree that the senior judges in this county are making valuable contributions to our system. I want to comment that Allegheny County is one of 67 counties in Pennsylvania. And there are many small rural counties that have one judge, two judges, or share a judge with another county. I think the senior judges are critical to the justice system in many of the other counties in this state.
Yeah, I think senior judges serve a purpose. However, as Mark alluded to earlier, I was surprised over the course of this journey, there was a discussion about eliminating some seats from what I understand. And I thought that was curious because I know there are a lot of senior judges that are working a lot, and it didn't make any sense to me. Why would you eliminate seats when there must be a lot of work out there? Senior judges are working so much. So I think you need to make sure the actual judges, the full-time judges, are working full-time and busy and are working their caseload. Certainly, if there's some overflow that the senior judges can step in, utilize their experience. I mean, they're obviously very experienced jurists. That can be helpful, but I think only on an overflow basis.
I would agree. I've never had an issue with senior judges. I've actually found them to be, a helpful part of the process. In large part because they do bring depth of experience to the table. That's helpful. And honestly, my experience also tells me that I really haven't had a difference between a judge who is 65 and a judge who is 75. I think it's a arbitrary number, and that really is, a question of the individual rather than the age.
I believe our next round of questioning will begin with Mr. Tranquilli. And again, I feel like I need to say that I am reading the questions that were prepared for me.
Some question.
Otherwise, well, it's one of our last questions, so I just felt like I needed to say that. Recently, Judges McDaniel and Della Vecchia were candidates for President Judge of the Court of Common Pleas of Allegheny County. If upon your election to the court, the same election was to occur, for which candidate would you vote and why?
Are you out of your mind?
Now you understand why I felt like I needed to just say that I...
Okay. Basically, I guess what I'm going to say at this point is that, if I had to make a call right now, I have never practiced in front of Judge Della Vecchia at all. I have practiced in front of Judge McDaniel for the last 20 years. I would cast my vote for Judge McDaniel because, to cite an old adage, better the devil you know than the devil you don't. I'm going to leave it at that.
That's good.
Okay. We will move this direction.
I'm going to take the opposite approach. I practiced before Judge Della Vecchia, and I've never practiced before Judge McDaniel, so I would cast my vote for Judge Della Vecchia.
Judge Della Vecchia's daughter and my daughter went to school together, so I'd have to.
No comment.
Our choice is either or any judge.
No, we can have two president judges.
Well, there's 43 judges.
For which candidate would you vote and why?
I would vote for Judge Della Vecchia because I practiced in the civil division.
I'd have a tough choice. I hate to have to pick two judges, especially when it's videotaped. But I guess I would have to go with Judge McDaniel because I I've tried more cases before Judge McDaniel than I did Judge Delvecchio, although I think Judge Delvecchio is a fine judge, too.
I practiced a lot in front of Judge Delvecchio, and so I would vote for Judge Delvecchio. That's not to say John and Joe McDaniels couldn't do the job. I just know him better. That's all.
I practiced in front of both of them, so I would either flip a coin or abstain.
I don't have enough information to give an intelligent answer. I'll abstain.
Yeah, I practiced extensively for Judge Delvecchio. Very fair, and I do not have as much experience with Judge McDaniel.
Judge Delvecchio.
And I have not practiced in front of either of them. I did my homework before I decided who to vote for.
And if I'm sorry, I wasn't keeping track because I didn't want to be the scorekeeper. If my calculations are correct, everyone has answered a question, has had a lead question. Is that correct? Is that correct? Then we will go back to Ms. Bush with our last question, and that is, please state your most recent judicial rating from the Allegheny County Bar Association.
My most recent judicial rating from the County Bar Association is highly recommended.
Recommended.
I just submitted my materials, and I'm due to be interviewed on the 18th of March.
My most recent was not recommended at this time. I'm proud of that because I made some people mad. It means I've been doing my job very well.
I'm recommended in my most recent.
I haven't got a rating. I've submitted materials for it. So.
Recommended.
I submitted my materials to be rated in March, but my most recent rating was in 2011, was not recommended at this time.
I'm highly recommended.
My most recent rating is recommended. I've only been rated once, and I'm highly recommended.
With that, thank you all very much, and we'll have some closing remarks.
I think, all right. Can you all hear me? Without the video, oh, all right. First of all, I really want to thank the candidates for taking this time to appear with us and to answer what I thought were some tough questions, maybe even unfair questions. But nonetheless, I don't know about you, but I was really impressed with their thoughtfulness and their depth and their enthusiasm after all these various trips. So another really And Mark, incidentally, another technique when you have a tough call is just to take a cold shower. Sometimes that works if you have a tough call. We're going to have a little social afterwards. I know you guys have run the gamut today, but to the extent you can join us, we'd appreciate it. I think there's cookies and coffee. A real note of thanks to Jeannie and Ian for organizing this. They really pulled the heavy oars on getting I did want to say that Judge Koza did have a representative here, even though the judge couldn't make it. Mike Mikos was here. I don't know if he's still here, but I hope he can chat with you afterwards. And final note is that are there any candidates here for non-judicial offices other than Dan Gilman and Jeannie Clark who we failed to acknowledge? Yes, sir.
I'm a representative of the campaign.
All right, and you're here. Okay, well, in that regard, let me remind everybody that the 4th Ward is having a non-judicial candidates night meeting. In other words, all candidates other than the judicial candidates on Tuesday at 7 o'clock at the UPC Center. And we invite everybody in this room to attend, whether you're on the 4th Ward Committee or not. I think, Jeannie, that's it. Do you have anything you wish to add?
Judge Jack McVeigh has sent his regards. He is running for Superior Court. And he's a 7th Ward person, so I'm very happy to announce that he's running. Thank you all very much. Thanks to the Pit Law Dems. Go eat the cookies. We have enough for 200 people. Thanks to Mike Sword for videotaping, and my very thanks to Lynn Hayes Freeland for